Okay, well, then 4499 Weitzman Place versus Southern Highlands, 731824. And appearances, please. Four. Okay, now I have all four. Go ahead, appearances, please.
Jeff Brower, 13834, on behalf of 4499 Weitzman Place.
Good morning, Your Honor. Dan Hill, 12773, on behalf of defendant Southern Highland Community Association.
Morning, Your Honor. Nate Rulis, 11259, on behalf of the Olympia defendants.
Good morning, Your Honor. Anthony Sassy, bar number 12486, on behalf of Federal Home Loan Mortgage Corporation.
Okay. Well, I appreciate it may end up being a moot point, but just friendly heads up, we don't show you all on this case. We have Weitzman on the case, and we have Southern Highlands. When you go into our parties tab, you know what I mean? Now, I know you've appeared before, so why you are not there, I don't answer that. That's not done by us. That's done by Master Calendar. But even on our printout, who did you not have? Yeah, which is the same things that we have on our other printout. And counsel already, Marshall, can you let, oh, I think Mr. Bone's gonna let him know he just missed his hearing. So, friendly heads up if that matters after today, not making any advance ruling one way or another, but yeah, I know, but we just don't, they've already appeared. Right.
And I think part of the confusion may be with the Olympia defendants, and that I can just explain from our point. There's been a bit of confusion that we had Olympia Management Services as well as Olympia Group LLC that were both named in the initial complaint. The amended complaint that then got filed removed Olympia Group LLC, which may explain some of it. I can't say that necessarily explains all of it, but that may be a reason that Olympia Group LLC no longer shows up.
Yeah, honestly, give you that heads up because, but presumably you got e-served with everything, right?
Correct.
Okay.
That's right.
So, stay tuned. Let's walk through what we have today, and then you might need to actually physically do notices of. We'll get that. You'll get that taken care of.
We'll sort it out.
Okay. So I have your motion. Okay. Have your opposition. Got replies, joinders. So, what I'm trying to get to the heart of this is, this court, okay, now when the court got the order in, okay, and I appreciate from the opposition saying it had to be refiled a couple different times, and you didn't speak with our department because our department doesn't tell you how to file things. That's Master Calendar as well, which they have their rules and they don't tell us what they're, you know, they handle things. So this case was never certified as a class. So I guess when you kind of give your argument, can you tell me how it, because part of your argument is that it was the class action rules versus a straight 41. So go ahead, counsel.
It would be our position, Your Honor, that it was a straight Rule 41.
Okay.
So that's definitely our position. Opposing counsel kind of brought up both. So we dropped a little footnote in our reply talking about, well, hey, we understand that opposing counsel might view this through Rule 23, trying to get the case dismissed, but that certainly isn't our view because the class was never certified. And so under a straight 41, there's no order even necessary. You just file the notice, and you know that's the end of the case as far as the cause of action. Right. It's fairly straightforward from there, Your Honor. Our issue would be we had extensive communications about how obviously we commend plaintiff for taking a case off Your Honor's desk and taking a case off our desk, and there's light at the end of the tunnel on this thing. Mm-hmm. But our
feel free to sit down if you all want to. I mean, please be comfortable.
Our conversations were that the one kind of caveat that Southern Highland was putting on this is that we did not agree to the absorbing of costs and fees. So what happened in this order that was submitted to Your Honor was it sought relief from the court, and it dropped a line in there saying the court orders the parties to absorb their own costs and fees. Yeah. Well, that was a relief sought from the court that never came in front of us, And so at this juncture, in the case there's an order from the court ordering the parties to divide fees when that was not an agreement.
Not to divide, it was to bear your own costs and fees.
Right,
Okay.
right.
Oh, okay. Now you filed joinder, go ahead.
I would say, and I'll just add one discrete point to this too, is that I think the Olympia, that encapsulates part of Olympia Management Services argument. The other one is that the order specifically says, as required by Rule 41, that upon compensation for defendants for their filing fees. And I just want to, we've never received a check for that. I don't
Okay,
know.
so you have a different issue, you have his issue, plus you never got your filing fees, is that right?
Right, right. And that's,
So what you're saying is it shouldn't have been closed because you didn't get your filing fees, which never really happens from our, see, you have to realize when you look at this order looks like you all were in agreement.
sure.
Okay?
And that's, I think
People don't
that's part of
submit
the
orders
issue
because,
too.
you know, the rules are you can't submit an order unless everyone's circulated and agreed upon it, since there wasn't any motion. Now, we get all the time, the Rule 41 depends on if it predates an answer or whatever, you know what I mean? The notice of voluntary dismissals, they don't even require us sign off. Usually they're a notice, but we'll sign it off because oftentimes party need it for their respective clients, insurance carriers, various things like that. And since there's nothing in 41 that otherwise could have it happen without court intervention, signing my name really doesn't add anything. So you haven't gotten your filing fees, you've got issues with fees and costs, and you have an issue?
We do not have an
I
issue,
didn't see
Your
anything
Honor.
on,
No.
okay.
I mean, to note, we have not received our filing fees and costs, but as it relates to this current motion before the court, we have really nothing to add.
Okay, go ahead, counsel.
Thank you, Your Honor. I'll make sure they get filing fees immediately within 24 hours of this hearing. Your Honor, I think we're here just for one reason, and that is that the defendant, Southern Highlands, made a strategic mistake. They simply forgot to reply and protect themselves. And so now they're angry that they didn't.
Reply to what, you mean, answer
They
your
didn't-
amended complaint?
That's right. They didn't answer the complaint. This the motion to overturn or to this motion now that we're here for, it shouldn't even be allowed. That we have in front of us when we have either a final judgment or an order as it relates to attorney's fees. They have that can't be brought under 60A, and if an appeal of attorney's fees needs to be brought by through a appeal of a special order, and we cited the case law for that in our opposition. As Southern Highlands specifically acknowledged, they're not contesting either the 41A voluntary dismissal, because that just required notice, or the 23, the Rule 23 class action dismissal, or permission of the court to dismiss that. They're just here about attorney's fees, but when they didn't cite in their motion the basis for the request for attorney's fees, we asked them for it in the opposition, and finally, in their reply, they gave it to us. It's NRS 18010, and if we can all just look at NRS 18010, it reads specifically that the court can make a decision on the award of attorney's fees without a motion, without the need for a motion, and that's precisely what the court did here.
No, the court, let's be clear, the court did not make it, I am sure whoever's phone is going to turn that off, please, immediately. The 8 signs around the courtroom really aren't to be ignored. Marshall, can you see can we get that taken care of? Because you all aren't going to get a clear record, and you probably want to hear, well, at least one side wants to hear my next words, or at least whoever disagrees and whoever agrees probably wants to hear it. Let's be clear, this court did not make an affirmative ruling on attorney's fees. What this looked like when the order came is that there was an agreement with the party to just voluntarily dismiss the pro forma aspect that comes under Rule 41 without having an answer. So the court did not make any independent determination on attorney's fees because there was no motion before me. There was no request for attorney's fees. There was nothing before me for the court to make any affirmative determination. So just so we're clear on that point, I mean, only I know what was in my mind when I signed it. It looked like a straight 41 that you all had agreed upon, and it was a resolution of just getting it taken care of, and really for the pro forma aspects that many people like to have an official order, because particularly since you were potentially raising class action allegations, many people, I'm just trying to think, there's another one just recently happened, I was trying to think if any of the council happened to be on Adiago. It's one of the Icon holding cases anyway. People oftentimes will say, look, we're going to treat this as a class just for settlement purposes, and so it's not truly a class, and that's fine as long as it's stipulated by the parties and appropriate notices and things have happened. So just so we're clear, the court did not make any affirmative determination because there was nothing presented to me. I did sign the order. Go ahead, counsel. Sorry, I didn't mean to interrupt.
That's fine. I mean, just to be clear here, I just want to just throw in the case law that's already been cited.
Of course.
On a motion to set aside, a motion to set aside is not permitted on an order, and I guess what you're saying is you don't consider this an order, for where attorney's fees, the issue of attorney's fees are addressed, and the case law supports that, and it's supported both in the Barry Linder case and also in the Barbara Ann Holler trust case, and those were in the opposition. But I respect what you're saying, Your Honor. Our position, however, is that the court has has spoken as to attorney's fees. We've received many references to the requirements for service under NRC 5A, and NRC 5A is very clear about this. No service of the proposed order to the other side was required prior to the submission to the court. It was required afterwards, and that happened. And finally, on the issue of sanctionable behavior, we were both in the defendant's motion and in their reply, they cite one case as a basis for sanctionable behavior, and that's the Young versus Johnny Ribeiro case, which involved blatant fabrications of evidence. If you contrast that, I think, with what occurred here, which was a 4 times, not 2 times, but 4 times a request from the clerk's office to sign off on this, and finally, each of those documents carrying the certificate of service, that same document being forwarded to the court. There's a far cry between what what was discussed in the Young versus Johnny Ribeiro case involving blatant fabrications of evidence, and here the party or the counsel acting at the direction of the clerk's office. I want to refer you to the footnote in our opposition, Your Honor, if I can. In the 5 orders submitted to the court until now, and I'll point you to the specific footnote if if that's helpful.
That's what you're talking about, yeah. Page 9 of 12, isn't it?
Is that the page of the footnote?
Footnote 3?
Yeah, that's right. Well, you know this much better than I do, even though I wrote this thing. We have, in one instance, one of the defendants including a certificate of service. We have plaintiff always including a certificate of service in proposed orders, but the party complaining here of sanctionable behavior was the one party that in its 3 proposed orders never included a certificate of service. It's the pot calling the kettle black in many ways here. And so not only have we followed the rules, but we're being accused of not following rules in a way that they themselves, didn't. So that's our position on our argument, Your Honor.
Okay. Go ahead, counsel. It's your motion. You get last word.
Okay, I'll be very brief, Your Honor. First off, I think Your Honor gets it, but just for the record, I'll clarify a few things. First off, of course, we have no issue with the voluntary dismissal. If it were just a straight-up notice, we would be in a perfectly fine position here because there would be no foreclosure of seeking attorney's fees, which is the main issue here. Also, we don't dispute the fact that this order need not have been served if it were circulated and approved by the parties and until it's signed by Your Honor. It's a little more macro than that. He sought relief from the court in the form of ruling that the parties cannot seek attorney's fees in this case. He got relief from the court by having this, Your Honor, sign that order without filing a motion or without even informally putting us on notice that he was seeking this relief. So we didn't have an opportunity to weigh in. That's where that's the issue here, Your Honor. And so even if we have no problem with dismissal, the entire order, the only issue we have is there's that one line that says the court orders the parties to absorb their own fees and costs. That's relief from the court that Your Honor understandably thought had been kind of agreed to. And certainly we've had amicable conversations with opposing counsel about getting rid of this case. That was just never part of the conversation. And so, you know, when that showed up before Your Honor, it was somewhat of a surprise, and that comes in that's a relief from the court that he got without service on us and without the opportunity to weigh in. So, as for the order, the only issue we have is that one little line about the parties are to absorb their own costs and fees. That was relief from the court that we didn't agree to or know about. In terms of sanctions, as our email exhibits demonstrated, we put plaintiff on notice, hey, we didn't agree to this, we haven't seen this order, we didn't get a chance to respond, can you walk that back? And he said no, and so now we're before this court with all these pleadings, just trying to accomplish that one little thing. Unless Your Honor has any questions, I think Your Honor gets it, and I'll just leave it at that.
Thank you. Joined your party?
Nothing further to add, Your Honor.
Nothing, Your Honor, thank you.
Okay, thank you. Here's what the court's gonna do. Okay. Court is going to strike the August 2nd order and take no position as to any of the contents thereof. So just so we're clear, the reason why I'm striking it is because it procedurally was improperly submitted to the court, okay? And the court's gonna deny motion for sanctions, but let me walk through my analysis so that everyone's on the same page. When the court received the order, since, you had just withdrawn your second request for a second amended complaint based on the totality of the circumstances and based on the order looked like a straight 41 that was agreed upon by the parties, that's why the court signed it, okay? Having now the benefit of the understanding that it was not submitted to the other parties, because our understanding, because as you've heard me say, some people say too many times in court, I always say, circulate all orders, and the rules require you to circulate all orders. So when an order gets presented to the court, it comes with that stamp of aura that it has been circulated to all parties, and so that all parties have approved in content or form. If not, somebody files either a competing order or an objection to the order, okay? So not having any of that, look like a duck, walk like a duck, get signed like a duck. Probably a very bad example, but you kind of get it. It's the day after Labor Day, But anyway, so the court would find it's appropriate to just strike that. And then if a new order gets submitted that just addresses the NRCP 41 relief, which isn't even necessary for the court to sign off on, if you need it for whatever purposes and there's no objection and it gets circulated, the court will sign that. But the court was not making any affirmative determination on any relief one way or another, whether it is entitled, not entitled to, because it really wasn't before it. And so I think the more prudent thing, rather than striking a portion of an order, is to strike the whole order. Anything that is being requested gets resubmitted after being circulated to all parties, and the court will address things at that juncture. In so striking it, the court is not implicitly or explicitly taking any position on any fees requests. I don't have it before me. I can't. It's an advisory opinion. I wouldn't do it. So, with regards to the sanctions portion, the court is cognizant that, look, here was attempted compliance. I think your opposition made it very clear with regards to what you were trying to do versus how it got submitted. While I'm appreciative of the communications and each party's position with regards to your negotiations, when I look at the standard for sanctions, I don't see that this is the type of conduct that would merit sanctions. And so the court would deny without prejudice the request for sanctions. The motion, I guess it's a motion for sanctions, so I deny without prejudice the motion for sanctions. Okay.
To clarify here,
Sure.
you're undoing the dismissal?
No, I'm not undoing the dismissal. I'm not undoing the substantive nature of anything. What I'm doing is I'm striking the order, because the reason why is the dismissal can be effectuated without this court signing the dismissal.
Right.
So I'm not.
So there are three parts to it. I just want to understand
Sure.
what your order applies to. So you're not you're not undoing the dismissal of the case. The case now is dismissed, correct?
The The simplest, easiest way to do it, well, this court does not provide any legal advice, but that's why I said if you were to resubmit an order of dismissal so that you want some clarity of the record that just says it's dismissed pursuant to NRCP 41, the court will sign that. The court's not going to sign something that gives affirmative relief which is not before it in the absence of the agreement of all the other parties. So I can do it that way.
I just want to understand what you're ruling
Sure.
on now. You're ruling on, you're not ruling on the dismissal of the case. The case now is dismissed, correct?
If that was the intention of you to do, yes.
Okay, and we don't have an argument on the class action, permission to dismiss the class action.
There was no class action certified,
Okay,
so
so
that's
that's not
not
the issue.
necessary. So that wasn't.
So specifically, what you're reversing here is the order as it relates to attorney's fees. Is that correct? Because there's three parts to this, their order.
To the extent that the order signed on August 2nd, okay? Here's what the order was titled, okay? The order was titled, Order Granting Plaintiff's Motion to Voluntarily Dismiss Class Action, okay? That could be appropriate to the extent you wanted to call it a class action and then get it dismissed. That would be appropriate. But adding into the order, to the extent that sub B require that the party to this action bear their own fees and costs subject to the, okay? And even the way it's worded, subject to requirement under NRCP 41A1 doesn't even necessarily say that the parties are waiving because there's nothing in 41A1 that says it, but to the extent that sub B can be read in a manner that this court was taking an affirmative position that no party would have any ability to request fees and costs. I'm not saying if they did it, I'd grant it because that would be another day, another motion, so I'm not either implicitly or explicitly saying that there would be any merit to if anyone was even to file a motion, whether there'd be any basis. But to the extent that this order would preclude it, that's affirmative relief that's being granted, as they correctly stated in the motion in the joinder, without an opportunity to respond to that.
And Your Honor,
And
specifically.
that was not filed as an ex parte motion, so it couldn't address it even under an ex parte motion standard. It was submitted as an order. An order is an agreed upon, either it's a direct ruling of the court, or it's an agreed upon matter between the parties. The parties all say it was not agreed upon, and it wasn't an express order because I had nothing before me in which to order it from. So sub B would be stricken.
And so-
I thought the cleaner way to do it was to strike the pleading and let you resubmit it with regards to the agreed upon portion, so then you have a clear record.
Specifically with regard to the reference to the requirement that an appeal of attorney's fees occur by a special order through the Barbara Ann Holler Trust case, which specifically addresses this topic. Are you on that?
I'm not addressing that, that's not
overruling
before me, no. Counsel, okay, we're talking two different things, okay? One is whether they're foreclosed from trying from whatever method they wish to try to do fees. I can't foreclose something without giving them an opportunity to argue that, okay? Because there was no motion and no ex parte. Now, whether or not they properly can do it is what you're arguing. That's not before me. Whether they can properly do it one way or another, whether or not my deleting the sentence makes any difference is not before me. But it is not proper for this court to be submitted to this court an order that asks for affirmative relief because you're asking me to make a determination on your viewpoint of the case law without giving them an opportunity to object to that. Instead, it was submitted as if, because remember, any order that gets submitted to the court comes one of two ways. Direct, well, and I even say this every time I grant something in open court. You need to circulate to all parties unless they've waived, right? So any order submitted to this court, to any department, has to be approved to content and form. Now, they can refuse to sign it, they can ignore you, and those are different things happen, but it has to at least be circulated to the other parties before it gets submitted to this court. The exceptions are ex parte orders, right, and OST orders, and there's probably a couple more that, you know what I mean, but those are my quickest examples.
What's the basis for that requirement? Because they recited NRC 5A, which doesn't have that requirement. So what's the basis for the requirement that this had to be submitted to them?
By definition, you can't submit something that's not agreed upon and ask the court to sign off on something and make it look like it's all agreed upon by the parties.
And so
It's
NRS
probably not my-
18010 doesn't apply in this situation?
Court's not making any determination with NRS 18010. I'm not saying whether they can file something or they can't file something.
The defendant cited NRS 18010 as the basis for their attorney's fees.
But the
specifically.
attorney's fees motion is not before me now. They're just, okay, I think you all are on different pages on what I'm seeing the brief. What I understood their motion is that, look, Judge, whether we do it or not, we have a right, we have not waived our right to fees. They're not asking me to an affirmative determination as to whether they get fees or not. That's not before me. I couldn't rule on that. I wouldn't rule on that. I need that as a full attorney's fee motion, okay? They're only saying, Judge, we didn't agree to waive our fees, so we don't want that in some order that we never saw. They're correct procedurally, and so that's why that provision wouldn't be there.
What's the procedure though, specifically the rule that you're citing? Because they cite NRS 5A, which doesn't have that requirement. What is the basis for your decision that's required, Your Honor?
I'm not sure what you're asking me.
They cited
Are you
NRS 5A.
saying you can submit an order to the court and ask the court to sign it even though no party agrees to it and ask for affirmative relief?
They
No,
cited
you
NRS
can't.
5A as a basis for the requirement that we should have submitted this to them before. NRS 5A does not have that requirement. They cited NRS 18010 as a basis for their attorney's fees. 18010 specifically says the court can rule without motion on its own on this. So I'm trying to understand
Rule
what.
unless it's in front of me. Now, you can rule on a motion for attorney's fees. Take, for example, a default situation, right? A default can include a request for attorney's fees because it can be pursuant to contract. It can be pursuant to a lot of different things, whether it's sanctions, etc. I'm not ruling on whether they can or can't get attorney's fees, and they're not asking me to. You're not asking me to, are you?
No, Your Honor.
You're not asking me to, right?
Absolutely not, Your Honor.
No, they're just saying they didn't waive it.
No, but we specifically presented this to you as we were properly allowed to under the rule, and you made a decision.
No, I didn't.
Oh, you didn't?
Okay, because you didn't properly submit it to me. In order for the court to rule on something, I've either got to get it by ex parte motion, noticed motion, or some different statutory basis, or some basis under the rule that allows something different. Like if we go into writs, I'm not going to go into a whole litany of appeals, right? This did not come to me. The ones that would normally apply here is either an ex parte motion or a noticed motion, neither of which came to me, right? So I can't make an affirmative determination that each party bear their own costs if it's not either by stipulation of the parties,
Can I
which,
quote from NRS 18010, in awarding attorney's fees, the court may pronounce the decision on attorney's fees without written motion. And that's precisely what you did, Your Honor.
no, that's not what I did, because that's not what you presented it as. You presented it as if it was an agreement by the parties, okay? I'm giving you the benefit of the doubt, which is why I'm denying the sanctions.
Yeah.
But if you intentionally submitted it to this court, knowing that they didn't agree for attorney's fees, then that's asking me to reconsider the sanctions request. I was giving you the benefit of the doubt that you did not intend to ask this court for affirmative relief, even though you knew the other sides had specifically said they didn't want to waive it. I took it as inadvertence, that you just took it as you're just trying to get done with this completely, okay? Giving you that benefit of the doubt is why I denied their motion for sanctions.
Okay.
If you intentionally were submitting to this court to make an affirmative ruling on attorney's fees without giving the other side any chance to provide anything to this court and not telling me that they had specifically disagreed, as they say happened by the emails, then what you're really telling me is I should grant the motion for sanctions, but my first ruling is fine. And that's not what I think you're telling me.
No, Your Honor, you're
I'm giving you the
precisely.
benefit of the doubt. I thought you
appreciate
liked the
that. I
benefit of the
appreciate that.
doubt.
I'm just trying to
Okay.
understand. I'm just trying to understand
Sure.
what you're ruling.
Counsel, you're in the back. Are you on this case, or you're just telling me you have to go to another case and need to
No,
get you?
no, I just wanted, I'm here for a different case.
Oh, no worries.
Part of why I'm standing is just to stretch my legs.
Oh, no worries. I just wanted to make sure if you wanted to make an appearance on this case, I was more than glad to.
No,
But
if
you
I'm
were-
here for a different case. I'm just stretching, sorry.
No, no worries.
If it makes more sense.
no,
to you.
you're more than welcome to stand up, stretch, whatever. I just want to make sure, in case you were making an appearance in this case, that I was getting everyone taken care of, because we would never try and call a case.
I think you called it before I came in. I did bump into my opposing counsel outside. I just want to make
Oh,
a record of that.
no worries. I'll take care of that in just a moment. Let me finish up this case. Okay. So, two parts to today's motion, right? One, the order. Order, they are procedurally correct. You asked me for affirmative relief, but didn't tell me you were asking me for affirmative relief. I took that you did that kind of with the benefit of the doubt that you did not do that intentionally, okay? So that's why I denied the sanctions. But at the same time, you did ask this court to rule on something affirmatively. Okay, EDCR 2.2, right? Any motion has to be properly noticed, given to the other side, and then there's specific rules with ex parte motions. In order to file an ex parte motion, you have to file an affidavit that tells that the other side that there's some reason that the court should grant ex parte relief, okay? I got none of that, right? There's no affidavit, there's no motion. The motions required under the EDCR require that you have to have points in authority. There was no points in authority. So you gave me nothing to allow me to rule on it, either as a motion that could be heard without oral argument, perfectly fine, right? You didn't give me anything that provided any points and authorities, which is what 18010 addresses, right? It has to have some points and authority. You're required to. Cattle versus Woods and Erickson for cost, Brunzell with regards to motion for attorney's fees, okay? Right? You didn't give me any of that. So I couldn't have ruled. So if I didn't rule, and it wasn't by agreement, it shouldn't be there, okay? So while I can rule under 18010, without the other side having an opportunity, then you at least have to have some affirmative basis. Brunzell tells you that, right? That tells me why you would get that. Because Brunzell tells you for affirmative of why you would get attorney's fees and goes through all the factors with regards, right, to how an attorney gets fees. So the same analysis would apply with regards to a waiver of fees. You didn't tell me or provide me any points and authorities on why affirmatively I should treat theirs as a waiver, right? There wasn't a single case in there, right? The absence under EDCR 2.2, right? 0 tells me the absence of any case law means that I can view it as non-meritorious, right? Or the alternative is to just say, look, benefit of the doubt, this was inadvertently filed. It was not intended to ask me for affirmative relief in violation of the rules, which is the way I took it. Deny the sanctions and strike the order because the order includes things that should have never gotten presented to this court without them having the benefit of looking at it, okay? Or addressing it. Or an affidavit that tells me why they couldn't under the ex parte rules. So when I go through every single aspect of how it could have come to me for me to make an affirmative ruling, nobody presented anything that says I could have ruled on it, okay? Without a single case, without an ex parte affidavit, right? So I couldn't rule, I didn't rule on what I couldn't rule. So that means sub B has to be out of there. There's
So this
two ways
case
for
is
sub B.
dismissed now.
Did it make sense? Let me just finish so you're clear. So sub B has to be out of there one way or another. Okay, which is the one that talks about fees. There's a clean way to do it, and there's a more convoluted way to do that. The cleaner way to do it is to strike the entire pleading, right? Because then we don't have a confusion of I'm affirmatively striking sub B, and then I get a new motion that says, well, since I affirmatively struck B, court, you really intended X, Y, Z. So if I said I'm intentionally not ruling on it, it just was inadvertently procedurally provided to me, and treat it as if it didn't exist, right? Nunc pro tunc, strike it. Nunc pro tunc, you submit a new order that just addresses 41. If you want it to address 23 and there's no objection, it can come to me, I can sign it, and you're back, everyone's happy and everyone moves forward, and whatever comes before me next, I address on the merits rather than, and that's a proper way to do it.
So is this case dismissed now?
If you want it to be dismissed, I can do it right now orally in court. In the absence, even with striking the order. If you want to submit an order, what do you want to do? Do you want it orally done in court? Do you want it to be viewed as nunc pro tunc?
I don't want to do anything new. I just want to know what your ruling is on this, because my understanding was that we submitted a notice to you for dismissal, and then it's dismissed. And now are you reversing that dismissal?
No, counsel. Under 41A, since they didn't respond, right? They didn't answer the amended complaint. Right. You technically have the right, okay? I can, just in case, handily, I have it in front of me. Under 41A, right, it says specifically, by plaintiff by stipulation, okay, subject to the provisions of Rule 23E of Rule 66, and any statute in action may be dismissed by the plaintiff upon repayment of the defendant's filing fee without order of the court. Okay. You haven't shown me that you've repaid the filing fees. In fact, you've acknowledged you haven't. So the answer to your direct question is no, the case isn't dismissed. If you've repaid their filing fees, and then you provide some notice that you've repaid their filing fees, we can easily dismiss this case under 41 from you. Okay. And it doesn't need anything from you all to sign off on, other than I need some acknowledgments that you repaid the filing fees, okay?
Yes, we'll pay the filing fees within 24 hours.
So the answer, as of right now, the case is not dismissed as soon as it gets processed for striking, so technically on our records it will show dismissed, right? But it's going to get reopened, okay? Until you file some notice that you've repaid their filing fees if you want it dismissed under 41. Okay. The other easier way I was thinking is you all could do a stipulation that you got your filing fees and what you wanted from your relief. If you don't want to reach out to the other side and do a stipulation, it'll happen pro forma once you file a notice of repayment of the filing fees and request to close it under 41. But you need to take affirmative action.
We will definitely pay the filing fees within 24 hours, so this case is dismissed.
Will be
take notice, I guess, of the fact that you've struck the part.
I was actually, the moving party prevailed, so normally I'd have the moving party prepare the order because you prevailed today. And then you'd have it circulated to all parties, as I always say, and then provide it back to the court, so we're clear what the court's doing, because you want to have a chance to look at their proposed order, and they want to have a chance, all parties, right? You all want to look at the order, right, for today's hearing? Yes?
Yes.
So unless somebody waives it, moving party prevailed, he'd prepare the order for today's hearing. Now, if you all decide in the intervening time that you've repaid the fees, and you want to add an order, and just do it as a stipulation to do it wrapped up nicely in one document, you're more than welcome to do so, but I can't require you to do so.
Stipulation as to what now?
Okay, sure. If you repay the filing fees in 24 hours, that's probably quicker than you're going to get your order prepared, circulated to all parties, and want to submit it back to the court. So one way to do it, which is optional, this is not an order, is if you prepaid the filing fees, is in the order with regards to today's hearing. It includes a line that the fees have been repaid and the parties agree that the case can be closed under 41. We're taking no position on any other aspects that anybody else doesn't want to take positions on. There's a lot of ways proverbial to get this done. How you all want to do it as attorneys is up to you, but for purposes of today, as soon as I get done with court today, and it takes a little while administratively, the case is not going to be dismissed because you haven't repaid the filing fees, okay? Which is the Rule 41 requirement, right? You give us a notice to repay the filing fees, that you've repaid the filing fees, right? We can close the case. Alternative 2, if you include in the order for today a stipulation that you've repaid the filing fees and that you all agree the case can close, that's another way. And there's probably a third way that you all have thought about, but I just was trying to do 2 quick ways, okay? I do need to move on because other parties are waiting for their cases. Thank you so very much.
Thank you, Your Honor.
Have a great rest of the week. I hope everyone had a very nice holiday. Okay, filing fee notice, you file a notice. You file an e-serve a notice of paying the filing fees, if you choose not to do the stipulation, okay? I do appreciate it. Thank you so very, very much. Okay, let's go back in my 9 a.m. folder. Thank you so much. Okay, counsel, you were here on a 9 a.m. matter that